like to call the hearing to order. I'm Linda McFadden. I'm chairing this hearing this morning. Our panel members are Robert Philick, who is here, and Valerie Rookham, who is on Zoom. Assessment Department is represented by Jason Brown, and our secretary this morning is Jaswinder Kumar. We don't have any other, everyone who's coming today is here, I believe, correct? Everyone's coming? Everyone who's here? Okay, we'll be hearing applications for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the Board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or to the Court of King's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included in the Board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions that the applicant may have, then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all of the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the Board will deliberate in private and make its decision. You will receive the Board's decision by registered mail as soon as possible. As information, all public hearings are live streamed and recorded and will be part of the public record. We'll be hearing items number 1, 4, 5, 7, 8, and 9 on our docket today. Mr. Kumar, will you please confirm the assessor and the applicant?
Thank you, Madam Chair. Mr. Assessor, please state your full name.
Jason Brown.
Thank you. Do you affirm that the evidence you are about to give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. So, Neufeld, please state your full name.
Rocky Neufeld.
Thank you. Do you affirm that the evidence you are about to give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you. Good morning, Rocky.
Hi.
Okay, the first item on our docket is 1611 Brookside Boulevard. If there are any issues here, Mr. Brown, would you like to proceed?
Thank you, Madam Chair. This is file number 22-2491. Roll number is 140966500500, and the address is 1611 Brookside Boulevard. We have a 2023 assessment using our reference date of April 1st, 2021. That assessment is $551,000. This is an industrial warehouse. Consists of one building with an effective year built of 1975. It has a 14-foot wall height and a leasable area of 5,500 square feet. There was a sale on this property. It is post-reference, which is why I've blacked out the value. It was also the tenant that purchased the building from the owner, which would be considered a motivated sale and would not be arm's length. We have a picture on the bottom of page 2. My rental comparables are located on page 3. We have a range in these comparables from 3,780 square feet up to 6,750 square feet. The wall heights range from 14 to 22 feet. And the effective years range from 1952 to 1974. So all these parameters are very similar to the subject property. And we can see that the rents for these comparables range from $5.54 to $6.50 per square foot. My capitalization rate evidence is located on page 4. I've highlighted the industrial section, which is what the subject property is. We can see a range at the 20th percentile starting at 5.55%. And that goes up to the 80th percentile, which is at 7.45%. This just means that all the properties located within the 20th to 80th percentile will fall between these ranges in our model. We have some outside sources to the right of those, and we can see they range from about 5 3/4 up to 7 1/4, depending on the type and the area and the outside source. My income workup is located on page 5. So we can see the leasable area at 5,500 square feet. We've used a price per square foot or rent per square foot at $5.76. We've reduced that by 4% vacancy and 3% expenses, and shortfall at $3.85. This gives us our net operating income of $28,654. And then we've capitalized that at 5.2%, which generates the value at $551,000. I have a map on page 7. So this is located north of the airport on Brookside Boulevard. I'll note that there is access to Center Port Way to the north of the subject. A zoomed in view below that. So this is close to the corner of Oak Point and Brookside, between Oak Point and Eagle. And then some aerial views on page 8. So this is a long rectangular shaped parcel. And then we have the main building, which is, I guess, in the bottom picture on the right-hand side. And then there's that Quonset hut, which I don't believe is on a slab or anything like that, so we haven't valued that. I have some exterior photos on page 9. It looks like this has been, the outside's been renovated lately. And then we have the plan on page 10 showing the site and the warehouse. We have the income and expense from the old owners. We can see NOI of 19,607, which is below what the model is. However, property management administration looks a bit high on that. We can see the income is at 50,400, which is above the model at 31,680. So it looks like our rent's a bit low on the model, but these are gross rents. I do have a breakdown of the rents on page 12, showing $9.16, but that is semi-gross. So based on that information, we ask that the assessment be confirmed at $551,000. Thank you.
Thank you. Students, do you have questions for the instructor?
Yes, I do. Yeah, so you confirmed that's a gross lease. So the potential rent wouldn't that be the 19,000 potential rent as full?
Yeah, but that property and management administration looks quite high.
Yeah, no, I'm not going to disagree with you there. Okay.
Yeah, if we stabilize that, I feel like it would be pretty close to the model, which is, I believe, at about 28,000.
Model is, sorry, I thought your model was
NOI 28.
No, well, that's after vacancy. I'm talking potential. Your model's 31,680, right?
Correct.
Okay. Now, in regard to cap rates, do you actually have any cap rate sales from this period?
Not located in my evidence, no.
Are you aware that have there been any of buildings like this, which I guess we'll describe as a pretty much a lower class industrial?
Off the top of my head, I haven't researched any of them. I did do sales verification when the model was being built, but that was testing my memory now. It is in a good location. It's a bit older. It looks like it's been renovated a bit. Obviously, we're finding that the smaller buildings are getting the lower cap rates, and that's based on actual sales that are verified.
The chart you have on page 4. Now you've described the city of Winnipeg as either single tenant A or multi-tenant B, correct?
The city of Winnipeg, like the model cap rates?
Yeah. I'm just looking at the rows, the ones that you've got A's and B's listed.
We don't generally break them out by A's and B's. Our model is going to look at size, area,
Okay.
Quality, stuff like that.
But the market sources you quote do break them down as A's and B's, right?
That's correct. Yeah.
And would you disagree with me if I told you that this is not an A nor a B? It's below that.
I would not disagree.
Okay, those are my questions. Oh, sorry. Did you haven't inspected though, have you?
No, I've driven by it, but I haven't been inside. No.
And just out of curiosity, page 10. This is old style assessing, isn't it? Where you actually used to sketch them out.
That is an old sketch. Yeah, probably from when it was built in 1975.
Okay, good to see those. Anyway, thank you. That's all I had to ask.
Thank you.
Thank you. Sharon?
No questions at this time, thank you.
Mr. Schiller?
Sir, I was wondering about your cap rate. When you go to page 4, just so I understand, I don't see where you reach 5.20.
Okay, yes. So that's a good question. So our chart shows that the 20th percentile starts at 5.5. That means anything below the 20th percentile, meaning from 0 or 1 to 20 percentile would fall below that 5.5, and vice versa with the 80th to 100th percentile would fall above the 7.45. This is just showing the properties that fall between the 20th and 80th percentile, so those 60% would fall between that range. Does that make sense? So there are some properties that fall below the 5.5, but that would only be 20% of the entire portfolio, the industrial portfolio. And vice versa, 20% of the portfolio would be above 7.45.
Thank you.
Thank you.
Just to follow up on that a little bit, you're telling us that this is largely low cap rate because of the size, because
Correct.
generally properties that would fall into the lowest 20% would be superior properties, and this is certainly not a superior property.
That is correct, and I'll admit that cap rate is probably a bit low, but I also think our rent's a bit low. I think if you move that rent up a bit, you could adjust the cap up to probably something closer to the 5.5. But I do feel that the value in the end is a good value for this property. It did sell for quite a bit more, but it is post-reference and it wasn't an arm's length sale. But for that size of property in that location, I feel like 551 is a reasonable assessment.
Okay, thank you. Mr. Newsell, would you like to proceed? Sorry.
Yes, thank you.
No problem. I'm sorry. I think I was wrong.
Sorry, go ahead.
Yes. Yes. In reference to the sale, first of all, it was a complete sale of the business and the real estate in one to a former manager.
The sale is
Yes, and I just wanted to clarify that it was what
we
the
won't be considering.
yeah. No, why this is probably of interest is that the tenancy was a book rent, And so what we did is we just looked at rents in the area, and although it is somewhat connected to Centerport Way, it is on Old Brookside development area, and at this point on Brookside, there's still ditch streets, and it's an asphalt topped with a lower load bearing capability. It's not the nicely developed poured concrete that modern industrial likes to see. It's been around since 1975. It's a very inferior location for a lot of users. The current use in Centerport is modern distribution systems in 100,000 square foot cross-dock facilities, not little pole sheds off the beaten path. Now, one of the issues with this is, and I'll get back to this later as well, is I pointed out the assessor's sketch on his page 10, and it's 100-foot lot width. And the reason it's inferior is very simple. A modern semi-trailer requires 125 feet to turn. The trailers are 53 feet, and the tractors are another, I think, 20-30 feet, but the way they turn means you need to have a larger lot, and this is long and skinny, and this is the real problem with this lot, and why it's inferior for modern use. So when we had looked at the rents, we'd looked at a bunch in our page 3, and most of the properties around this class were now hitting around $5, and that's what we applied. But because of these issues, and yes, I have inspected it. It's really not much of a building. As I said, what we call this is I think a pole frame construction with it, which is just a normal style of framing, and it's low ceiling height. I know that the assessment department has a different way of measuring. They're calling it 14 feet, but if you look at the pictures, that 14 feet is the peak and doesn't include the width of the trusses. Generally, to look at the effective height is the clear height, and looking at this clear height is approximately 10 feet, and that's the right denominator for this determining what's height, and that's very much at the low end of the scale. In our chart, page 3, we don't report exterior heights. We focus on clear heights, and as you can see, the 10 feet is a fair bit below what we would usually see in buildings, industrial style usage buildings. Operatively, again, go back to utility. You can't put a semi-trailer back one into it because the semi-trailer is higher than 10 feet. The trucks rule the earth in industrial, and if you can't adapt to the truck, you have limited usage. In this case, it's a contractor's establishment, and it works for them, but that's a limited use market sector. Not broad enough to, if you only have one use for a property, your demand is lower. You don't appeal to a lot of different users, and that's the downward pressure. As far as the vacancy rate, we looked at 2 areas. First of all, use the Johnson report because they have all the documented vacancies, and we look at single tenant and investment rates, which is how you would have to look at this. That's page 5. Looked at its location, which is closest to Inkster and the overall city industrial, and blended the rate to 5.2%. Not a major issue in relation to what the assessment has worked up, but we are trying to stick to market, not models. In terms of non-recoverables and structural reserve, we know the assessment department has decreed 3% is the rule in their model. That's not reality. That's not market. Market is shown by our pages 33 and 34. These are samplings of Collier's managed properties. They're a mix of retail, office, and industrial. And non-recoverables are reality. It's cash flow. It's always follow the cash. There are always non-recoverables. Some years they're high, some years they're low. The concept of putting an expense on them is to stabilize for periods where they're higher, and the high period is usually a tenant turnover time. So when you're stabilizing, you have to remember that these costs will come. Our cap rate is I was asking the assessor a question about cap rates because about if he had any, and I can say that there has been a very large scarcity of cap rates in industrial properties like this one. Generally, we won't see any at all. I think there have been a few large size investment ones. More actually are happening in the RM Rosser immediately north because there's been some developments and sales happening there. Of course, this is not modern industrial. On our page 24 is our industrial tracking, and Class A, Class B, we are between 6 and 6.75%. But then when you go to definitions on page 25, we do not, this property does not meet the definition of Class A or B. And I mean, I'm part of the Collier system. This is not an investment property. This is miscellaneous industrial. And it doesn't go lower than these rates. It goes higher than these rates. So what we do, as we normally do with the scarcity of rates, we look at our model, our own model, which has been derived by two means of actual sales where they exist, and then following the split between bank yields and bond yields, and focusing on the spread, which is called band of investment capitalization or mortgage equity capitalization. Both methods that were in existence a long time before direct capitalization was ever used. And on our page 2, we start with a base rate of 6% and then look at the negative features of this particular property. And our cap rate study, first of all, includes the closing costs for the investors' cap rate, or the purchasers, not the sellers. We adjust for that. We adjust, it says no access from highway. I would change no to poor. And by poor, I mean all things considering, which is the roadway, the access to turn into the site, the method to get to Centerport Way. It's not conducive. If you look at the picture on page 1 of the overhead and imagine a modern semi-trailer trying to leave any of those properties on Brookside and turn onto Brookside, what of note is on picture on page 1 is all the pictures on the east side have their narrow approaches, and then there's a modern one with semi-trailers parked on the the west side, and you can see the larger flared approach. And that approach is almost as wide as the subject property's actual lot is. It's physically impossible to do that on the subject because they got a building on the site. You'd have to move it. So that's a negative. The size is small. A good size in Winnipeg would be typically 20 to 30,000 feet. That's more optimal. And investors don't want smaller buildings. Remember, we're talking about investment rates, not purchases by owner operators. If we're doing the income approach, we have to focus on the investment approach. So there is less demand for small space because they don't meet the needs of the investor. The design and layout and the low ceiling, year built, that's obvious. Quality and condition, full frame construction, aged. Yes, they put a little bit of face brick on it, but I think that's their business too. And the roofing company, it's just a real basic construction. And one point, and I've been forgetting to discuss this, and it came up yesterday. When the assessment model talks about age, they have this effective year built, and it's a one feature that kind of defines their physical age-related deficiencies. We break it into 3: year built, quality, and condition. So you're built, you can't change that. It is what it is. Quality and condition you can change with upgrading and lack of deferred maintenance and looking after the site. You can't make a building new again, but you know, you can stop it from descending. Those were the main issues, and we came up with 7.5%. And this does produce a number that is somewhat low. And so the test on this is at some point, your value, if it drops below the price of land, then you should default to the land rate. Because someone could buy it and then knock the building down and have a site. And we had considered that. Our problem here is the configuration of the lot. And if you notice the lot in our picture on page 1, if our lot was more similar to the property immediately south, or you see the two of them there with 200-foot lots, that would be reverting to land. Could be something to consider. I think that it's a very difficult sliver of land to work with. I don't see, like, theoretically how we could have strayed from proper valuation procedures on this. That's my presentation. Thank you.
Thank you very much. Mr. Brown, do you have questions? You're muted, sorry.
Thank you, Madam Chair. Yes, I do have a couple questions. So your value of $303,000, that represents a pretty big decrease from the 2020 cycle. Would you agree?
Yeah, but that's your number, not mine.
Was it, or was it the board number? I'm not sure.
I don't even recall what it was.
Okay, but that wasn't appealed to the municipal board or anything like that, right?
I don't know. I never check.
I can check right
Yeah, for me, it's not really relevant. We're just looking at what it is.
now. Okay, so that was confirmed at 472 last cycle, and it is pending muni board. So.
Okay, all right.
So, but this is a small increase over that at 551. I'll just note that.
Sure, but you're asking questions, and my response to that was a small increase over a number that's not valid means nothing.
I understand. Your vacancy at 5.2%. Where was that derived from?
Johnson report.
Which is located on page 5?
That's correct.
Okay, I'm just not seeing the 5.2 in there.
Oh, what we did is, I gotta make sure we did this right. Take a look at the column 2021, and by the way, this was sampled, the end date for the sample size was December 31st, 2020. The publication was in 21. Inkster, you'll note, was 4.2, and overall rate was 6.2. And, maybe St. James might be a consideration as well, but you can see that particular area, the northwest quadrant, we were just averaging those rates.
Okay. It looks like some of the areas have 0% vacancy. Is that accurate?
No, and that's why we do our sampling of looking at the overall. Like, for example, Murray Park is 0 because it's dominated by 2 owner operators, Boeing and MacDon. So there's like 6 buildings that are investment, and the sample size is so low that you wouldn't use it. None in the Exchange District, and in Elmwood, like, there's 3 old warehouses. So that's it. Why we like the Johnson report is we can look at the sample size as well. And Inkster and St. James have the largest, so they deemed to be more accurate.
Okay, thank you. Just quickly turning to your page 24, you had mentioned that there was no industrial sales. Yet this page is stating that transaction volume for industrial has returned to pre-pandemic levels.
Well, what we're tracking are mostly Rosser and Arm & McDonald, because that's the Canada Way sales were the ones that just put everything off the chart. That's all. I mean, they put up, I'm trying to think how many millions of square feet in a short period of time, and that happened after Rosser finally approved the development plan. There's a 10-year hold on it as they tried to arrange their water. And when they finally secured the water, the RM approved the plan, and all this pent up deals were in place, and overnight you saw millions of square feet go up. Major impact on our market. We include that in our sampling, by the way, as Winnipeg.
Okay. And just one last one. You've got small industrial rental rates and large, I guess page 3 is the larger industrial rental rates. That's accurate.
Yeah, I'm just looking at them. I think that these were just the product of a bit of slothfulness. We just copied some old reports and updated a bunch.
Oh,
there
yeah,
might be some.
those are older, yeah.
There might be overlap.
Generally, as a rule, the smaller industrial will have a higher rent per square foot, right?
Yeah, if they have good utility, they should. They should have a better rate. And you know, the exceptions to it are, you know, some of these ones are fairly inferior that we had looked at. Like an example, the top one on page 3. No, those are dated sales, dated rents. Yeah. Let me just look at. Aaron is more. I'm looking. Sorry, I'm now looking at page 4. The top one has got a bit of Aaron, a bit of a retail to it. Cree is in that Moray, and that's actually an office. The Mountain View are in Rosser. Myrtle is just off Notre Dame. But then when you get to Dawson, which is real industrial, $490. Brooklyn is a bit of an office. There's another Dawson. I think that's it's the same one renewed. So I think it speaks to quality. You have to speak to quality as well. 1681 Church is probably a really good comp. I think it's like the same building style, except it's in a multi-tenanted site, 473.
Okay, those are my questions. Thank you.
Ms. Warren, do you have a question?
None, thanks.
Mr. Philip?
No, I haven't.
Mr. Neufeld, your cap rate at 7.5, the assessor has made a case that smaller properties or smaller buildings have less risk, and you're clearly not agreeing with that.
That's correct. You know, what happens with some of the smaller buildings is that the transactions are usually not a cap. Like, for example, if you want to look at this building and tried to use it without realizing that there was an owner-occupant issue in there, you can take the cap rate on the sale that happened would have been astronomically low, and that's what happens to the sampling size. There's another property which you're not going to hear today because it's off the docket on Dougal, but it's a small building. It's sold. It had a tenant in it, but the tenant left, it vacated, and then it was sold. And I think that's what makes it look like they have low cap rates. If a property is sold on its investment capability alone, the small building carries a higher risk because if you have one vacancy, it's 100%. Whereas a bigger one, which multi-tenanted, you spread the risk around. And secondly, the refilling that, which is the risk level, when a tenant leaves and you've got to replace them, you've got to sell them the amenities. So putting this one back onto the market, the lack of semi-trailer access reduces your pool of potential tenants, which indicates a higher risk to an investor. Now, if this were located in an area where there was a bit of retail appeal, then I would agree more with the assessor, because then you have other users possible for it. This does not have other users.
Okay, thank you. That's all the questions. We'll move on. Is there any summary required by either of you?
No, thank you.
No, we're good.
Okay. We'll move on to 1565 Dougal, and I understand that there's an issue with this, a preliminary issue with this one.
With Dougal, I believe I've just got communication from the appeals manager in that I believe it's been removed from the docket.
Oh. All right.
Now, I'm not the official source, but that's what she told me.
I'll check on that. Thanks, Rob.
Oh, we just want to. No, I haven't received anything.
I got an email at 9:08.
Can you send the email?
Can you send us the email?
Oh, sure. Let's see, do I have any, okay, looks good. Yeah, I just forwarded that,
To
the Board of Revision mailbox. I've been pestering Visa all morning, so I think she's probably buried by my requests.
Yeah, okay, Madam Chair, yeah.
Okay.
These are just confirm this removal of this site.
Thank you. Okay, we'll move on to 550 Roseberry, which I understand again, there is a preliminary issue.
That is correct,
There-
Madam Chair.
There's actually two preliminary issues, and I don't know how you want to deal with this, but I want to follow the correct procedure. The assessor has his preliminary issue in regard to the request for penalty. I received this notice yesterday, a little before noon. I have not been served with this. And I had forwarded some information earlier to the Board of Revision, just some excerpts from some of the provincial acts on service. And I don't think that that was adequate to serve me about 21 hours before the hearing that there's a penalty request. And it's no fault of the assessors. It was a procedural hiccup problem. He served the board on time. They never forwarded it to me. And they have admitted they haven't served me. And my point is simple. You can't, any offense is governed by different laws and different reasonable rules of reasonableness. We need time to prepare. Now, in this case, we would normally look to get legal counsel, because I do not like to be arguing law issues. That's not my qualification. And I did try to secure legal counsel for this morning, and I could not get one on short notice. I think that the appropriate matter with this is, because of the notice, is you should just quash it, summarily quash it right now, the request for penalty, because of the unfairness to the taxpayer. And I don't think the assessor has a say on this, because he's got nothing to do with it. It wasn't nothing he did. But
I understand. I understand that there is a procedure laid out by council, a policy laid out by council for how evidence will be handled, and that if you are not submitting evidence on the 14 days ahead, that you're required to make a request for the evidence from the assessor, and that request was not made until yesterday.
Yes, and as I did send the board something this morning, and it's called Acts, and these are just excerpts from provincial acts. And even if council makes a bylaw, council can't change Manitoba law. This is a Manitoba law that's being enforced. Council can have procedures as much as they want. In this document, I don't know if you have it, called Acts.
I do not. However, we are governed by council.
That's fine. The provincial act speaks to that as well.
I'm going to recess until the panel can.
I just want to say what it says on here under the Act for Enforcement of Municipal Bylaws is that the period to respond must not be less than 30 days after which the penalty notice is delivered. That's what the Act says. Now, we've waived it and gone for 15 days, which may or may not be legal, but one day is not.
Fine, we will go into recess. Thank you.
Okay.
Thank you. The hearing will resume. Mr. Neufeld, the panel has considered your request and we have determined that we will proceed with these properties. So in that case, Mr. Brown, do you have an issue I think that you want to raise before you start your piece?
That's correct, Madam Chair. I'd like to go through the non-cooperation argument as a preliminary matter in order to determine the burden of proof.
Okay. So would you want to read it into the roll?
Okay, I'll proceed with the non-cooperation argument. So the roll number is 0702110400. We are seeking that the burden of proof be placed.
Sorry, do you have the file number for that?
Yeah, the file number is 22-3095. We're asking that the burden of proof be placed on the applicant for non-cooperation under section 53(3)B, and the reduction in assessment order that it follows 54(3.2) of the Act. We can see on page 2, there was requests sent in 2019 for the 2019 information year in 2020, and once again in 2020, or for 2020 we sent in 2021. There was no responses received. So the next 4 properties are all owned by the same company and they're all going to be the same issue. I'm going to go into it a bit more detail on this property, and then I'll just go through the information on the next 3. So these are all Computer Plus. You'll see on the first page.
Mr. Brown, I just want to mention though that we have to go through the procedure with each property.
Of course, yeah. I'm just going to spend a bit more time on this one.
Perfect. Thank you.
So we can see the owner on the first page is Computers Plus Limited. The next 3 properties are all going to be the same owners. They're all going to be signed by the same person. So I'll just take you right down 16 of my evidence, please.
Sorry, we cannot hear you any longer.
Okay, can you hear me now? Is that better?
Yeah, you're good. I think both of the other people's are frozen.
Oh,
I said our.
hang on for a second. Everybody's frozen.
Yeah, our connection is weak now.
Pardon me?
Our connection is weak actually.
Okay.
Okay, I think we will stop.
Okay, I think we're back.
Okay.
Everybody there?
Everyone can hear me now?
Yes.
Okay,
Okay.
go ahead.
So this property is owned by Computers Plus Limited. If we go to page 16 of my evidence, please. This is the Canada Post tracking. We can see the tracking number LP657141982CA. This was delivered on the 6th month of 2021, and it was signed by Daniel Stefanovsky. I looked up the name Daniel Stefanovsky, and his LinkedIn does show that he does work for Computers Plus at the mailing address of 620 King Edward. We can see that he signed for it. He did sign, it doesn't look like his name. It looks like it says as for. However, he did give his name, Daniel Stefanovsky, and he did put the pen to sign. It just doesn't look like his actual signature. On page 17, this is the blank mailer that was sent out. We can see at the top left, there's that tracking number again, LP657141982CA. This corresponds with
Page 17, we don't have a page 17. Do you have a page 17? This is 550 Roseberry Street. I don't have a page.
I have no 17.
I'm down to just 16.
That's strange.
Wait a minute.
Mine is showing a page 17. Mine shows all the way to page 24.
What I see is a tracking on 60.
And then nothing else?
Nothing
Nothing after
16,
that.
no.
No, nothing.
That is very strange because mine is showing 24 pages and I'm currently looking at page 17.
No, all we have is 16 pages, Jason.
Okay, so was the file corrupted or something? Because I'm looking at the actual file that I sent and mine is showing 24 pages. How would you like to proceed?
I think you should continue verbally while we,
Would you like me to resubmit the evidence with the 24 pages and see if that works?
Yeah, well, wait a sec. See, it's the whole problem all over again. You can't resubmit. You got to give us the proper notice, even though we only got 21 hours to look at it. This is what you got.
But to me, this is going to boil down to a technical problem because I did submit my 24 pages and something must have happened since then.
Too bad for you.
Well, I mean,
I
it's up to the
believe
board
you
to decide.
yes. Go ahead and resubmit, please.
Thank you, Madam Chair.
We're going to recess. I have a question.
We'll read it.
Won't take too much time.
Well, I have to object again. Like, we can't send allegations again, no notice. This is an appropriate procedure.
You're gonna take time, Jason? Should we go on a break?
It's, I just sent CLK board.
I've noted your objection, Mr. Neufeld.
I haven't got it yet.
It's showing sent in my sent folder. It's not a huge file, so it shouldn't take too long.
I got it.
Okay, thank you.
Okay, it's in the folder, Madam Chair, with the revised.
Okay.
Okay,
It'll be in the folder.
Yeah. Just underneath that previous file.
Has it been added to the original 550 or it's in separate folder?
No, it's the separate file. I just put revised at the end of that file.
Okay, and we're now 6 pages.
Okay, I'm just gonna.
Have you found it?
I haven't received anything.
Oh, there's no new file?
No,
Okay, just give me
You
a
might
minute.
have to right click and then hit refresh in that folder.
It's at the very top there.
I have
Got it?
received it now. I have it. Yes, thank you so much.
I'm sending an email to you, Mr. Neufeld.
Okay, I'm gonna ask for recess, please. Yeah. Thank you. Sorry. I'll call the hearing back to order. I would like to state first that I was in error allowing the assessor to resubmit. We will disregard that submission. We haven't looked at it, so we will completely disregard that. However, the rules do allow for the assessor to give verbal evidence. So, Mr. Assessor, please go ahead with your evidence and we will consider your request.
I just don't understand how, if I submit my evidence and then something happens to it before you guys get it, how would that be on me? What could I have done differently to change this outcome? I feel like I did everything that I was supposed to do, and now,
I would like to set that aside for the time being, please, and have you.
I just don't know how I can even give verbal evidence on this. A lot of the evidence in the next file is the same. I would like to maybe move on to that file and hear this file at the end.
What's the purpose?
Pardon? Mr. Neufeld.
Could we move on to the next file and move 550 Rosedale to the last file? Because a lot of this evidence that you guys are missing that I did submit is contained in the next file. And I'd like to just move to that file and then end with Roseberry.
So we would move to 620 King Edward. Is that what
Yeah,
you're?
I would think that that's not appropriate. A file is self-contained. A hearing is self-contained. You can't. Obviously, you can ask questions about previous evidence, but you can't use the evidence from another file to apply from one to the other. And in addition, the hearing has been opened. I think there's a requirement to close the hearing and then move on.
You're certain that you cannot give verbal evidence, Mr. Assessor, Mr. Brown?
Well, no, I don't understand how I could. The whole point of seeking non-cooperation is to show that we sent a blank mailer, and if I can't show that, I'm at a severe disadvantage here. And I'd like to state that I could not have done anything differently here. There needs to be a protocol on submitting electronic evidence, because I'd like to know what I could have done differently to avoid this.
And I commiserate with your plight, but I was under the same problem not having received the evidence, and it cuts both ways.
But I did submit. I did everything that I was in, had to do in order to submit evidence for this hearing. And then because something happened from the time I sent it to the time it was received by the board, and now
Mr. Brown?
I feel like the legitimacy of this appeal is in question.
Sorry, I'm going to recess again to consider your request, Mr. Brown, that we move to a different place.
Thank you.
Thank you. Sorry for the delays, everyone. Okay, we are live. Okay, I'll call this hearing back to order. So we will not be moving the agenda. That's not appropriate. Mr. Brown, we will be looking at the 16-page brief that we have in front of us. Do you wish to proceed with this particular 550 Rosebery? You may do so verbally if you wish. Sorry, you're mute.
I just had an email with Rocky. I just want to confirm that he's still on.
Yeah, Mr. Mercury and I had it forced me to drag Jamie out of bed and attend the hearing. And so now we had a discussion and it's going to come out sooner or later. So may as well just get it over with and deal with everything at once if the board's okay with that. Otherwise, we're going to be dealing with 4 separate penalty cases, and Mr. Brown's correct. It's one case. Get it done and move on. If that's okay with the board.
Mr. Newfield, procedurally, I need to open each file separately, deal with their non-cooperation and close it again.
Right.
Decision to close it. Procedurally, that's what I'm required to do.
I think what Rocky's suggesting is that we just look at the revised brief for this.
Yeah, and that we provide consent and withdraw our objection. If that works.
If I may interject here, and sorry, I'm coming to this a bit late, but I've been briefed in terms of what's happened here, and there appears to have been some form of glitch. I don't know where the fault lies in terms of the missing pages, but I briefly reviewed it. It appears that the assessor's position on the penalty is likely going to be the exact same. He can correct me if I'm mistaken on all of these. So let's just, my advice to Mr. Newfield, and I think in fairness to everybody, is just let's allow the documents to be put forward and just deal with the merits of the matter and allow Mr. Brown to proceed with his submission, and we'll deal with it. And the board can make a determination, I expect, on this matter, which I believe will be determinative of the various other matters on the docket, at least with respect to the penalty issue, unless, of course, Mr. Brown advises there's different evidence on those, but I don't believe that's the case. I think it's the same submission.
Thank you, Mr. Mercury. That's all correct.
All right, with everyone's consent, we will now open the newly submitted revised brief. I would note that we have in the past allowed for corrections to be made to briefs as we move forward. So given that everyone's on board, we'll move to 550 Rosebery and the 24-page brief.
Madam Chair, I have to swear in Mr. Mercury.
Pardon me?
I have to swear in Mr. Mercury.
Okay, we need to swear you in, Ms. Mercury.
Okay, Mr. Mercury, please state your full name.
James Mercury.
Do you affirm that the evidence you are about to give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, please go ahead.
Thank you, Madam Chair, and thank you, panel members, and thank you, Mr. Mercury and Newfield for sorry for any confusion, and thank you for rectifying that. I'm going to start over from the start. Page 1, this is file number 22-3095, roll number 0702110400. Address is 550 Roseberry Street. We're asking that the burden of proof and that the reduction in assessment both follow 53.3B and 54.3.2 of the Municipal Assessment Act. Page 2, this shows a request for information. Requests were sent out for both information year 2019 and 2020. Neither of those were received back. We haven't received an income and expense statement from these properties since 2018. Moving on to page 16 of my brief, this is the Canada Post tracking. So this was delivered on June 10th, 2021. It was signed by Daniel Stefanovsky. I did Google this particular person's name, and I did find a LinkedIn profile for them stating that they did work for CDC Computers, which is the owner of the subject property. I'll note that the tracking number is LP657141982CA. Moving on to the next page, this is a copy of the income expense questionnaire that was sent to the mailer, or to the owner, I apologize. So this was sent June 9th, 2021 at the top right-hand corner. Top left-hand corner, we can see the corresponding tracking number that corresponds with the signature on the previous page, LP657141982CA. This was sent to Computers Plus Limited at 620 King Edward Street. Once again, it was signed for by Daniel Stefanovsky. He was, the signature does not appear to actually say Daniel Stefanovsky, but under contract law, you can sign with an X, a squiggle, a drawing, as long as that, whatever the pen put on the paper corresponds to, you know, it acknowledges that you have signed for it. So there's the blank mailer on the pages through to page 21. And then we have the supplemental questionnaire starting on page 22. That's the COVID questionnaire, also blank, not received back. And on page 24, we have the application for this file, signed by Tony Batista, which is the director of Computers Plus Limited. I'll note there's no address on the application, but the mailing address for this property is 620 King Edward, which is also owned by the same company. Based on that information, we ask that non-cooperation be granted and that the burden of proof be placed on the applicant, and that a reduction in assessment would not take place till the following year. Thank you.
Thank you. Mr. Newfield, questions for the assessor about this?
Yes, just a few questions, Madam Chair. Just looking at page 16 of the brief, Mr. Brown, and you've indicated there's the box, the signature box, there's as for, it appears to read. Do you agree?
That is correct. There is a number of properties under the same ownership, all signed by the same person and all with that signature. We're going to see it in the next three properties as well.
Right. You stated that under contract law, you can sign with an X, but you'll agree that I'm not sure what you're getting at there, but you'll agree that at least on the image page, it does not appear to indicate anyone's name in particular. It's just the words "as for" is all we see.
So in my experience with Canada Post, they'll come to your door, they'll ask you your name, which I assume happened here. Mr. Stefanovsky gave his name, then they'll hand you some sort of tablet with a pen. At that point, in my mind, the second the pen hits that tablet, that's your signature. All it is representing who that person is, and you know, it can be a squiggle, it can be a picture, it can be an X. But the second that they ask you your name and then you touch the pen down, that's a signature in my mind.
Okay. Now you say Daniel Stefanowski. You don't have anything in your brief that would show what his relationship actually is with the company, whether he had in fact authority to. He's not a director of the company, is he?
No, but if you give us your mailing address at 620 King Edward and Canada Post comes and you give your name and you sign for it, and then your LinkedIn says you work for them, to me that satisfies those requirements.
Well, okay, so that's your position. So the city's position is that so long as a person at the whoever happens to be there at the premises answering the door or receiving the mail, as long as there's a signature there, that satisfies the delivery of the INE?
Correct.
Okay, so we have submitted some documents in rebuttal, and Mr. Brown, in fairness, have you had an opportunity to review the municipal board orders on this particular issue and what constitutes proof of service under the Municipal Assessment Act?
I have not received rebuttal evidence.
Okay. Well, that has been supplied. Perhaps that could be made available to everyone at this time.
Yeah, I'll read them.
What was the case you were citing?
So there's a few. Mr. Neufeld had initially supplied a number of PDF documents, and then I had just submitted one additional case. I just want to make sure the board receives it or has it.
Just give me a second, please. Okay, it's in the folder, Madam Chair.
Okay, we have 7 documents.
I believe that's correct.
Brown, do you have those 7 documents as well?
I do not.
Send an email to you.
Did we just get something new?
Okay, these are now your presentation, are they?
They
are your...
Yes, they will be. They will be part of our presentation. I just, in fairness to Mr. Brown, I wanted to ask if he was aware of any of the municipal board orders in light of his position on what constitutes proper service. So I just wanted to give him the opportunity to address that.
Well, before we deal with all of that, I need to give the board a chance to ask any questions that they have of the assessor.
Yeah, yes, that's fine. And so I think maybe the appropriate way to proceed is to those are really the questions that I have for Mr. Brown. So if the board has questions, then I think we would proceed with our presentation and go from there.
I had one question. I'm looking, Mr. Brown, you referred to the other cases being heard today. Did you have an opportunity to compare all 4 signatures today? The as-force?
I mean, I made the evidence 2 weeks ago. At that point, I would have seen them all.
I'm looking at all 4. I'm not a handwriting expert, but they look like they're photocopies that have been transposed onto a background. They all have the same, all the same, and then they got the little. Sometimes it's clipped in the little picture or something in the top right corner. Sometimes it's
not possible that how many properties does this company own? Say at least 8 that I know of. Is it not possible that 8 envelopes were dropped off and just 1 signature for all 8?
I don't know, and that's my question to you.
It appears that that's what happened. I don't think that Canada Post would make them sign for each separate document.
But then wouldn't the service and the lack of proof of service then required to have an individual signature for each envelope because they're all marked by different tracking numbers.
That's true, but is it, and like I said, I'm not a kind of a post employee, but to me, it would make sense that all the tracking numbers would be supplied on one page and you would just sign for them all at once.
Well, yeah, now you're talking about Canada Post policy. I was just asking if you had a chance to look at that, and the signatures here are all the same. So you didn't look at that then. That's all I wanted to ask. Thanks.
No, they appear to all be the same, whether or not he signed them all individually the same or was just one signature for multiple.
I've never done mine the same way. So.
Ms. Wareham, do you have any questions for the assessor?
No, I don't. Thank you.
Questions?
I'm, based on what Rocky has just said, when I look at all those signatures, are all these businesses connected together by the same owner?
Correct. They all have the same ownership. They're all owned. If you look at the top on my front page of the next 4 properties, they all say Computer Plus Limited as the owner.
I have no questions. Would you like to proceed, please, with your response? Mr. Neufeld?
Yes, I think I can start. Mr. Neufeld can just add any detail that I may have missed. He's provided a number of documents. First off, I'll note that the mailers would have gone out during a period of time. This was during COVID, of course, when a number of restrictions were still in place in terms of what businesses were fully operating or not. I guess it was very, very much hit and miss. But our submission, what we provided to you are 3 municipal board orders. This question of what constitutes proper service has obviously come before the board of revision a number of times, including this cycle. It's also come before the municipal board on a number of occasions. So there's a few more recent cases that have addressed this. What I would say is the leading decision on this is a case called Mo Investments, and that's found in your rebuttal material. And what happened here was the mailer was sent to the address in question, yet it was actually received by an occupier of the premises, in particular the tenant occupying the space. But there was no evidence that the mailer was actually brought to the attention of the owner. And so the question became whether that constituted proper service for a deferral order to be made under the Municipal Assessment Act. And the board found that that was not proper service. The onus remained on the assessment department to prove that the owner was actually served. So in that instance, they made it very clear that by simply delivering a document to an occupant, whether they be an employee of the business or a tenant actually occupying the premises, does not actually constitute proper service, nor does evidence of just sending it in the mail. So understandably, I would suggest the municipal board is saying to us that this can be a very significant and severe penalty. And in the circumstances, there's a high onus of proof on the assessment department to show actual proof of service on the owner, not on a physical person or occupant at the building, but somebody with authority to actually accept the document on behalf of the owner. So that's the first case that we put before you. There's a second case Mr. Neufeld provided called Boeing versus the city assessor. That case is slightly different facts, but essentially the penalty was requested and denied. The evidence was that it was sent to an address by registered mail. It was signed for by there was a signature on the Canada Post documentation but nobody could really say who that person was in terms of their authority to accept service on behalf of the owner, and the penalty was again denied. The final case that we put before you is a case called Russell Inns. That was a very recent decision before the municipal board, where the provincial municipal assessor was seeking a penalty on the basis that they had sent various documents to this address. The taxes were being paid, and they argued that there must be some form of inference that it must have come to the attention of the owner. And the board again denied the deferral penalty, saying just by simply putting evidence of that it was mailed is not evidence of service under the Act. So finally, what's been provided to you by Mr. Neufeld is a series of recent Board of Revision orders from this cycle. And now, while I appreciate these Board of Revision orders aren't necessarily technically binding on this panel, they are nonetheless important in that it's essential that the board apply this particular provision of the Act consistently and equitably amongst the various taxpayers. So I think the document is titled Penalty Cases. And so Mr. Neufeld has provided a number of board orders, one of which interestingly involved Computers Plus. It's actually, if you look at page 4 of
Actually, several involved them. I think there were 3 or 4.
Okay, thank you. Several involved Computers Plus, the very same owner that we're talking about here. So, for example, page 4 of that document, you'll see 943 Notre Dame. The owner was Computers Plus. And then page 5, 1376 Winnipeg Avenue, again, Computers Plus. And I think that, and then finally, sorry, page 8, there was another appeal, 939 Notre Dame. And so in each of those cases, I understand it, Mr. Neufeld can speak to it, but it's the same cycle, the same time period that was we were dealing with, and what occurred there is there was a Canada Post tracking sheet, and the tracking sheet indicated that the item had been delivered, but there was no evidence as to either who signed for it or the person who may have signed for it, what their position was with the company, and particularly given that the COVID period of time and the restrictions that were in place, the board, at least in all of these cases, not just the Computer Plus cases, but the various others as well, the deferral penalty was denied in all of them. And so I would suggest, consistency is important for this board, and also applying the direction from the municipal board orders that we provided to you. So in light of that, what I would suggest, in the absence of evidence that there was, this was served on someone with authority to accept documentation, in light of the orders from the municipal board and the Board of Revision, the assessor in this case, in my submission, clearly has not met their burden of proof under the Act. Finally, what I will note is that more recently, the Municipal Assessment Act has been amended as of 2022. So prospectively, there's a new section in the Act which is much more administratively friendly, shall I say, to the City Assessment Department, because there's a deemed receipt provision in the Act now that says that once a document by mail is sent in the mail, it's deemed to be received 3 days later. That section, though, does not come into effect until 2022, or did not come into effect until 2022. You can find the section for you if you wish. But these mailers occurred in 2021 before the legislation was amended. So going forward, I would expect that the board, these types of requests can be dealt with on a much more expedited basis, and the city will be probably relieved to know that that there's a much easier way of dealing with these things, but rightly or wrongly. But as the law stands as of 2021, you must actually prove receipt by someone, not only a physical person at the premises, but someone with authority. So those would be my submissions. I don't know if Mr. Neufeld has anything to add in terms of the material that's been provided.
Yeah, just a little bit. There was another case where we're just waiting for the board order on, and that was sent, and it's called penalty case 2. And I just sent you the agenda on it because we're waiting for the official order, but the penalty was denied on a property. And you'll see in that file 3 Reinders. That one, same issue. It was sent to an address in British Columbia. And the same issue with this one, which was closures. Sometimes, and a couple of these cases, the board has actually said to us, we're denying the penalty because businesses were shut down during COVID. And sometimes they say it to us, sometimes they don't. But several of these cases, that was the fact. And of course, our subject site was shut down for COVID. They had to. The province ordered it. They're not an essential business. And so it makes it very difficult to, but that was the reasoning. The other thing I sent in was I did track down this Daniel Stefanovsky, and I sent you a copy of his signature. It's marked Daniel. That's how he signs his name. So that's not his signature. That's not even his style of writing. If you look at, I mean, again, I'm not a handwriting expert, but you look at the signature itself. I mean, look at the F. There's a dead giveaway, or the S's. This isn't the way this isn't a signature. This wasn't written by him.
Which document are we talking about now?
It's called Daniel.
Pardon me?
I don't have a copy of that.
Oh, I sent it all in this morning.
Non-compliance Daniel signature.
Yeah. And
Oh yeah.
I don't have it, but it's not a big deal. I don't think it's a big issue.
Well,
We've got it.
obviously,
Okay. Mr. Brown, do you have questions of Mr. Neufeld or Mr. Mercury?
Pardon me? Sorry?
oh, and just
Do you have questions of Mr. Neufeld or Mr. Mercury?
I'm sorry, I'm having trouble hearing you.
Do you have questions of Mr. Neufeld or Mr. Mercury after the presentation?
Yes, thank you, Madam Chair. So the mailing address for this particular document was 620 King Edward. You'll agree?
Well,
with my evidence.
actually, I haven't seen an envelope on your evidence. Like usually they put in a copy of the envelope that shows where it was mailed to. You didn't have one, so I don't know.
But you'll note that the mailing address at the top left of the document on page 12 is 620 King Edward.
Yeah, on the letter, but that letter, of course, is not the original letter. That is a copy, but I'm not denying that Computers Plus corporate office is 620 King Edward. That is correct. I'm just saying you didn't
I was just getting at that it's not a tenanted building. It's owner occupied, correct?
Actually, no, they have 2 businesses running in there, so that there is some space that's used by somebody else on the second floor on the east side.
Okay.
Not Computer Plus.
Thank you.
I have, sorry, Ms. Warren, do you have a question?
No, thanks.
I just have one question, and that is that the penalty cases that you've set us actually doesn't give us the Board of Revision's decision. Each one of these ones, sorry, which one? The 8-page document, it just simply says the assessor provided an income and expense analysis, and then it says over, and we don't have the over.
Oh, some of them. Yeah, I see that the last one has an over, Numbers
Yeah,
one,
several of them do. Actually, every one of them does, except for the first one, which is the only one where we can see that the last one has actually does say that it was denied. But most
no,
of them-
numbers 2 to 7 say denied. And, I'm reading them. It's number 1, doesn't have it. I missed the over, and number, 8 doesn't have it.
Number 1 does have the decision, though, it's denied.
No,
Number 2 doesn't.
no. Yeah, and actually I had those right on my desk in front of, I missed the, number 2 has it. It's,
No, I see where they are now, thank you, that's all my questions.
yeah, okay. Well, all I can say is I was there. And they were denied.
And Mr. Neufeld, are you telling us that Mr. Stefanowski was not an employee of this company, or that it is irrelevant whether he was an employee?
Well, first of all, based on what Mr. Mercury said, it's not relevant. But the people who are the appropriate people to send it to are always on site. It's Tony Batista, Debbie Batista, Remington Batista, and I forgot the other son's name. I always have this mental block with him, but it's a family operation. One of them is always there. But they were shut down during this time. Mr. Stefanovsky, I believe, was in sales. But which kind of begs the question, if you're shut down for COVID, why would you be showing up to work and doing sales? It's just not his signature.
Just on that, Madam Chair, can I just ask a couple questions?
Sorry?
Just on what Rocky just said, can I ask a couple questions?
Yes.
Thank you. So places were open for like curbside pickup and online sales, correct, Rocky?
No, they were shut down to the public. I actually went there during COVID. They helped me out with a little problem. There was some tech people working in the back. I called Tony up, who I know personally, and Remington, his son, took me in and helped me with the problem. But
So
the doors were locked to the public.
The doors were
I was there to witness it.
The doors were locked to the public, but what you're saying is they weren't selling anything online? I couldn't have bought some computer parts online during that time?
Oh, I don't know. I'm not sure.
Okay, thank you. That was my question.
We will go into recess, please, to make the decision.
Okay.
Okay, we'll call this hearing back to order. The panel has deliberated at great length, and we have decided that the city's request will be denied. So, Mr. Brown, would you please proceed?
So, before that, I'm just going to depart at this stage, but thank you very much. I think that ends my participation.
Thank you, Ms. Mercury. Sorry to hold you up for so long.
No, thank you.
Thank you. Okay. So we are dealing now with 550 Roseberry, correct? Mr. Brown. I think you're muted.
Apologies. Sorry, Rocky and I are just negotiating during the recess. I'm just trying to get a handle on what we've talked about. Okay, so I'd like to make a recommendation at 715,000, please.
Sorry?
I would like to make a recommendation on this property to reduce the assessment from $748,000 down to $715,000.
Okay. Property? Recommendation, so 550 Roseberry, it's already been read in.
Correct.
And we've got a verbal recommendation to reduce to
715,000.
715, 15.
715, correct.
Okay,
Mr.
sorry,
Neufeld.
we had this bet going here. I don't know if that's the right number.
Can Rocky and I have a quick 5-minute recess just to get our numbers in line, please, Madam Chair?
Sure, we'll recess again. Thank you.
Okay, it'll be worth it. Thank you.
Thank you. Okay, we will call this hearing back in session. And I think we were about to have a verbal recommendation from Mr. Brown.
Correct. So for the file on 5, let's make sure I get this right. 550 Roseberry. We'll be making a recommendation to 715,000.
715,000.
Correct. 715.
And Mr. Neufeld, how do you feel about that recommendation?
Yes, we're accepting that.
Thank you very much. We will move on to the next item on our docket, which is, I think, 620 King Edward Street. Number 7. And again, I think we have a preliminary issue.
Correct. Let me know when you'd like to start, when you'd like me to start. Are you ready?
Yes, we're ready to go. Thank you.
Okay, sorry. Thank you, Madam Chair. This is
Sorry,
file.
you're coming in and out. You're coming in and out, Mr. Brown, so I can't understand you.
Yeah, I know, and I think I'm having the same issue here where things are cutting in and out. I'll try and speak clearly, and hopefully it works.
Thank you. So if you just read in the roll number first, and so we've got it on the record.
Okay, roll number is 0700187200, and this is file number 22-3089.
3089. Thank you.
Once again, similar to the previous property, we're requesting that the burden of proof be placed on the applicant and that the reduction in assessment be delayed 1 year for non-cooperation. On page 2, it shows our request for information for 2019 and 2020. Those were not received. We haven't received a submission since 2018. On page 12, shows the blank mailer. And on page 11 shows the signature from Daniel Stefanovsky. Once again, this was delivered June 10th, 2021. The tracking number was LP 657141979CA. If we turn to page 12, we see that same tracking number at the top left-hand side. Once again, this was sent to 620 King Edward, which is Computers Plus Limited, which is the subject property. And then the following pages are just the blank mailer, which was not received back from the owner. And on page 18, we have the submission for the application for the Board of Revision file. So based on that information, we ask that non-cooperation be granted for this property. Thank you.
Mr. Neufeld, your position is the same as we've heard?
Yes, I believe all of the next 3 properties are identical, same owner, same issues, same arguments, and love to go through them again if it's necessary. If it's not necessary,
I don't think that's necessary.
pardon me.
I don't believe it's necessary for you to go through the.
Okay. You know that microphone, I had a hearing yesterday, and at the head of the table, I think that microphone has a problem.
She may have turned it on.
Because it cuts in and out. I'll just
try to lean in a little bit. Is that better?
No, it's still cutting in and out. I think it's an equipment issue, but I can hear everybody else perfectly. It's just that the head of the table, same as yesterday, clips.
Okay. Thank you. Board, fellow panel members, we have deliberated on this previously, and I assume that we can rule the same. Our discussions will not change. I don't want to have to go back into recess. No. Are we agreed?
Yes.
Ms. Wareham?
Yes.
Okay. The city's request for non-cooperation is denied. Would you proceed, please, with your evidence, Mr. Brown?
Okay, thank you, Madam Chair. The department would like to make a recommendation on this property at $550,000, please.
Verbal recommendation. And Mr. Neufeld?
Yes, we are accepting that.
Okay, $550,000, that's correct. Okay. Moving on to the next item on our agenda or our docket is 650 King Edward Street.
Thank you, Madam Chair. Roll number 0700186500. File number 223091. Once again, we're seeking that the non-cooperation and the burden of proof be placed on the applicant. Once again, we haven't received a mailer since 2018, and I have all the documentation starting on page 14 through to page 22. Based on that, we ask that the penalties be granted. Thank you.
Mr. Neufeld, your position is the same.
That is correct.
Okay, based on our previous deliberation, the panel is denying the city's request. Would you please continue, Mr. Brown?
Thank you. I'd like to make a verbal recommendation at $805,000, please.
I didn't quite hear you, sorry.
805. Verbal recommendation.
805.
Correct.
Mr. Neufeld?
Yes, we are accepting that.
Right. Moving to the last item on our docket today, which is number 1561 Aaron Street.
Thank you, Madam Chair. Roll number 13011576500. File number 22-3088. Once again, seeking penalties for non-cooperation, no return since 2018, and all my documentation starting on page 11 through to page 17. Based on that information, we're asking that the penalties be applied. Thank you.
Your position is the same.
That is correct.
Based on our previous deliberations, then the panel is denying the city's request for non-cooperation. Will you please proceed, Mr. Brown?
Yes, thank you, Madam Chair. We'd like to make a verbal recommendation to $700,000, please.
That's $700,000, correct?
Correct. Yeah.
Mr. Neufeld?
Yes, we are in agreement.
Thank you. Guys are champs. Thank you very much.
Appreciate it.
Yeah. We have heard all the items scheduled, and this hearing is now thankfully adjourned.
Okay.
Thank you very much.
Thank you.
Gentlemen.
Nice to meet you all.
I'm sorry for all the delays and confusion.
Have a good day, everyone. Thank you.
Thank you.